and then I'll hand it over to our presiding officer, Andrea Williams. I ask that everyone, again, keep your cameras on at all times so we can confirm the attendance. I myself am just the administrator, so I will be turning off my camera and my microphone, but I am available here if you have any questions with regards to process. All right, so our live stream is running and I will hand it over to Ms. Williams. What I will be here for, Andrea, is to read in the evidence if you need any support with that, or you're welcome to read it in yourself.
Good afternoon and welcome to this Canmore Local Assessment Review Board hearing. I would like to remind everyone that the Assessment Review Board hearings are open to the public and this hearing will be recorded and streamed live. The video recording will be our record of hearing. We are here today to review the complaint and subsequent evidence as filed for tax roll number 12163. And the property is at 326 Silvertip Close in Canmore. I will start by introducing the panel and then ask the parties to introduce themselves. After that, I'll explain our standard hearing procedure and ask for comments in that regard. My name is Andrea Williams and I am the presiding officer appointed to this panel. The other members here with me today are Karen Mara and Michelle Willett. Does anybody have any objection to the panel as constituted? Okay. I'm now going to have the parties introduce themselves. I would have ordinarily started with the complainant. The complainant is listed on the complaint form as Marie-Pierre Boissonneau. She is not in attendance today, and so to the respondent, could I ask you to please, for the record, state your name, organisation, and your position with the municipality?
Sure. I'm Christopher Snellgrove with Benchmark Assessment. We provide the assessment services to the town of Canmore.
Okay, thank you. Just 1 second here. Okay. The Assessment Review Board standard practice is to have the complainant present all of their evidence first, followed by questions from the respondent and then the panel. Next, the respondent presents their evidence, followed once again by questions from the complainant and then the panel. The complainant will then have an opportunity for rebuttal. Finally, both parties will have an opportunity to present their final argument and summarise their evidence for the panel, with the complainant presenting first. If anyone needs a break or if a problem comes up, please let the panel know as soon as possible and we can address those things as we go. And I'll also take this time to remind everyone to please turn off any mobile devices. Are there any questions regarding the procedure today, or is everyone satisfied with the process as was laid out? Okay, let's see a little bit. I see both parties have just exchanged disclosure evidence before the hearing. To save time, I'll propose that we mark all the documents for the record now. That won't stop people raising questions about admissibility later. If any such questions arise, we can deal with them and strike material from the record later if necessary. Is everyone comfortable with this procedure? Okay, and I see we have a complainant disclosure, and it's marked as C1, 1 page. And then I have a respondent disclosure, which is 38 pages, and I'm proposing to mark that as R1. Right, okay with those. Okay, with the evidence, can I ask if there are any preliminary matters for the panel to address? Okay. So we do not have any evidence from the complainant aside from the disclosure form that we've marked as C1. So I am assuming we're going to skip to the respondent's evidence, please.
Okay, thank you very much. Okay, so I guess on page 3 of the document, the respondent disclosures, where we'll start. We'll just review the issues that we have here. First of all, issue number 1, has the complainant met the onus under section 460-9 of the Municipal Government Act and demonstrated how the assessment is incorrect? 2, has the complainant met the evidentiary burden of proof under section 460-9 of the MGA and demonstrated the assessment of $1,015,000 is incorrect? And should the complaint be dismissed under the authority of section 467-2 for non-compliance? So page 4 shows the subject property itself, some of the physical details of the property and the value that we have placed on it for the 2022 assessment year. Page 5 goes into our argument on this matter. So the complainant had a duty to disclose the documentary evidence in any written argument by September 12th. The notice of hearing sent August 3rd outlined the disclosure responsibilities. The complainant was required to provide disclosure to the Assessment Review Board clerk and the opposing party, benchmark assessment consultants. The complainant failed to provide any evidence or argument on or before the required date to either party. As you can see, the matters relating to assessment complaints regulation below there shows it is clear that the board must not hear any evidence not disclosed within the legislative timelines. Furthermore, there isn't anything to hear. The quote says, a local assessment review board panel must not hear any evidence that has not been disclosed in accordance with section 5. So the onus to prove that an assessment is incorrect is the requirement of the complainant. This principle has been well established by the Court of Queen's Bench and adopted by assessment review boards. And there's four examples just below that, showing other decisions that support that the complainant bears the onus, basically. Page 6 there, boards have dismissed in the past complaints where the complainant has failed to disclose documentary evidence. And there's 3 examples just below that of other board decisions supporting that. And then below that, in addition to bearing the onus to prove that an assessment is incorrect, the complainant also bears the burden of proof to demonstrate that the requested value is correct. And below that are four board decisions supporting that they have that burden of proof requirement. So the middle of page 7 there, the complainant has a multi-step requirement to demonstrate to the board a change in the assessment is necessary. First, the complainant must show that the assessment is incorrect, and second, convincingly prove that the requested value is correct. And in the absence of both, boards have decided that a change is unwarranted. There's further decision situations below that as well. 1, 2, 3, 4, 5, 6. 6 other decisions where that happened. So evidence in support of a requested value must be disclosed in hard copy for the board to consider. Hearsay evidence should be given no weight. So in other words, just an opinion of value without anything to back it up should really be given no weight. And there's a decision backing that up just below that. So I guess page 9 is our summary. The assessment submits to the board that the complainant has not met their onus, hereby not providing sufficient evidence that the 2022 property assessment of their property is incorrect. The onus of providing the incorrectness of an assessment is on the individual alleging it, and the onus rests with the complainant to provide sufficiently compelling evidence on which a change to the assessment can be based. In this case, it is the position of the assessor that there has been no evidence provided by the complainant to support their position, and that the assessment is incorrect. The burden of proof has not been met by the complainant, and therefore the respondent respectfully requests that the assessment board dismiss the complaint under the authority of Section 467-2 for non-compliance with Section 460-9 of the MGA. That's all.
Okay. I think ordinarily at this time we would have the complainant's rebuttal evidence, which we do not have any, and then we would have a summary following that from the complainant and the respondent. I'm not sure whether Mrs. Snellgrove, you have any summary that you would like to make?
No, I do not. That was basically summed up at the end of the disclosure there on page 9.
Okay. And to my fellow panel members, have any questions that they would like to put to Mr. Snellgrove? Michelle, no? Okay. Well, thank you for your presentation, Mr. Snellgrove. At this time, I'd like to ask you if you feel like you've been heard today and feel that you have received a fair hearing.
Absolutely.
Okay. And in the absence of that, I think I will now declare the hearing closed. No further evidence or submissions may be received by the board.
Thank you.
Thanks very much. The Municipal Government Act requires a written decision within 30 days and gives the clerk an additional 7 days to issue that decision. We will make every effort to meet or beat those requirements, and the clerk will forward our decision to you at our earliest opportunity. I think, given that we're at the end of today's hearing, we can ask you, Mr. Snellgrove, now to log off, and I think we can close this hearing.
Yep, that's great. Thank you very much. So I'll just make sure that our live